May it please the court, Don Howarth for the petitioners and appellants here, Your Honor. I'd like to save 10 minutes of my time for rebuttal, if I may.
Very well.
We're here on an appeal regarding severe sanctions for discovery responses that were late. And therefore, we're here on the application of the discovery statutes and case law relating to discovery issues. We have an order below for $37,000 in monetary sanctions and issue preclusion sanctions that are nearly case dispositive. So just to set the landscape, I don't think there's any dispute about this by the parties. The law permits such sanctions only where there is a failure to comply with a court order that was willful, an order that is not punitive, and where the remedy fits or matches with the violation. And as to the monetary sanctions, where there is a finding that the party acted without substantial justification. So in that context, we're limited to our record here, like scientists to their data. And when you look at the record, Exhibit 27 is the order number 11, recommendation and report number 11, which became the order of the court without change. On page 13 of Exhibit 27, the discovery referee asked the question, have the defendants ultimately provided responses to discovery? He never makes any findings. He says, yes, they've given depositions, yes, they've produced documents and so forth. Then he states his basis for his order, and he states it 4 times on that page. The responses have not been timely provided. They have not been timely and voluntarily provided. The law requires timely compliance, failures to timely comply. So we have an order based on timeliness, not on a refusal to comply, not on a failure to obey a court order. The respondent, though, takes the position that there is a violation of a court order here. And that's an important point, I think, here, because the respondent quotes to, on page 33 of their brief, a report and recommendations that said there's been a blatant and without apology disregard of virtually every discovery order. They say that on page 33. They say it 2 times on page 36, quoting the same thing with a reference to the underlying record. But if you look back at page 17 of the respondent's brief, they give the source of that quote. And the source of that quote is with regard to report and recommendation 8 and 9. It is not the current order. All of those quotes that they base their claim that this is a violation of a court order on relate to a different report and recommendation, not to the one at issue here. There is no such language in this one. That one, by the way, report and recommendation 8 and 9 had to do with depositions, which were not at issue in connection with this order. And there were no sanctions for issues preclusion in connection with 8 and 9. So that language, page 33, 36 twice, 3 times, that's their basis for saying there was a violation of a court order, relates to something entirely different than what we're faced with here, and it's not part of the record on this order. I understand, desperate times, desperate situation, desperate measures, but the court has to look at the record on this case and on this ruling, not on something that is not before the court. As a second...
Well, before we get off of this point, if a party fails to comply repeatedly does the court have the right to consider that when a new noncompliance consists of not responding timely? If the order says, do this by the 12th, and the 12th comes and goes, and the court says, is he just late or is he refusing to do it? Can't the court consider what has happened in the past?
Certainly. And if in this case, if the finding were that these documents and these responses had not been provided by the time of the order, then that would be a disobedience to a court order. That is not the finding, and that is not the evidence. They made a claim that all the responses hadn't been made by the time of the court order, and the defense put in a substantial 50-page chart showing that all of the documents and all of the responses had been made or would be made by the time of the order. So that when we come to the issue sanctions, the court has to look to what is before it, and if it's going to grant issue sanctions that virtually dispose of the case, it has to focus on whether there is an actual disobedience of a court order and whether that is willful.
But you're not arguing that it has to make that decision based solely on this particular instance?
Well, if you want to consider the past instance, then it has to bring in fairness to the parties. If it's going to say because you've done this in the past and you're doing it here, then it has to let the parties present and argue that point. But you can't take a stray reference from something where no issue sanctions were given and say, that supports a violation of a court order here. We're faced with this day, this challenge. The defense put in their defense and said, we produced all of this. We've answered all this. The court says 4 times, well, you were slow in doing it. It wasn't timely. I'm not saying that's not important. I'm saying that under the discovery statutes, that's not a basis for dispositive sanctions.
Okay, I had misunderstood your argument.
All right, thank you, Your Honor. Now, there's a second important factual issue here. When there are discovery sanctions that are case dispositive or are issue preclusion sanctions, they cannot be to punish. And again, we have to look to what the actual record is here. We're bound by our data. They cannot be to punish. What do we have here? We have a specific...
Yes. Excuse me, let me interrupt you. I apologize.
Not at all.
Before we get to the substance of the issue preclusion sanctions, don't we need to consider whether they're inextricably intertwined with the monetary sanctions? Because as you know, those issue preclusion sanctions are not by themselves appealable, correct?
Correct. On the issue of appealability, and I didn't want to spend a lot of time on it, but I will turn to that, we are exactly in the situation of the Milikowski case. We are in a situation here where the issue sanctions and the monetary sanctions are in exactly the same conduct, and that's what the referee below said. He said, monetary sanctions aren't enough given this conduct, so I'm going to have issue preclusion sanctions too. So they are, exactly in the words of Milikowski, based on the same conduct and therefore intertwined and to be reviewed at one time rather than to have the same conduct reviewed twice. And the respondents essentially concede that, Your Honor. At page 10 of the respondent's motion, their motion before this court, which is being decided with the appeal, they urge this court not to follow Milikowski. You can't distinguish Milikowski. It's exactly the same situation. It is exactly the same conduct that both are based on. So yes, the court needs to consider it and to consider it at this time so that we do not go through a complete wasted trial and then a reversal and then another trial. That's what Milikowski stands for, and it is still good law. They're asking you not to follow it. You should follow Milikowski. It's absolutely good law. And it says when they're based on the same conduct, that means they're intertwined. We look at that conduct once, it's judicial efficiency. We don't look at it once here for the monetary sanctions, and then again for the issue preclusion sanctions when they're the same. So I do think that it's ripe and that you do consider it now under the Milikowski case, which you should follow, and not accept their invitation not to follow that case.
There is case law that talks about the distinction between the analyses that you would go through to determine the propriety of the monetary sanctions versus the propriety of the issue preclusion sanctions, referring to the Doe case.
Yes, and they cite the Doe case, but in the Doe case, what was not considered on appeal was not the sanctions issue, but whether or not an order compelling compliance with discovery going forward was a part of the appeal. That's what the Doe case said is not part of the appeal. It considered all of the sanctions issues, but said we're not going to now get into this additional order of the court saying that you got to comply with this discovery order.
It was third-party privacy rights, as I recall, in the Doe case, and wouldn't we have to get knee-deep into some of the things you've touched on as part of your introduction of the issue preclusion issues in terms of the propriety, the connectivity between the conduct and all those types of things, which we don't have to get into in terms of the monetary sanctions?
No, here the only it's all the very same conduct. It's the late discovery, late compliance, and nothing more. You don't have to get into anything other than what is the text of finding number 11. What is the basis on which the court issued all of these sanctions? And you have to review that basis and see whether that complied with the law. Now, whether you call that, we say that's de novo with this court, but they again agree that even if it's not de novo, if you don't comply with the law, it's an abuse of discretion. So on either standard, here it's like a railway station that you slept through because it comes to the same thing. They didn't follow the law on very serious issues, and therefore the court, because they're the very same issues, under Milikowski has to consider them now. And it isn't just that. It was the lateness, as specified in the order, compared to not violating a court order, not willfully. But the other basis for the finding, the stated basis for the court's finding in Exhibit 27, page 14 was, based on this conduct, the same conduct, monetary sanctions alone will not deter future discovery abuse. Monetary sanctions alone will not deter. That's number 8 on page 14 of Exhibit 27. Now that language is virtually out of the cases that we cited on page 17 and 18 of our brief, including the McGinty case, where the court said the sanction here is pure punishment intended to deter violations of court orders. So you have a specific finding on the timeliness being the issue, and then a finding here that I need to give these sanctions in order to deter future violations, further violations in the future. That's by definition under the case law punishment. And that the court cannot do on a discovery motion, on a discovery matter. So it's a timeliness, not disobeying a court order, and a specific finding that the basis for the sanctions is to deter future violations, that is to say, to punish. I also want to say something briefly about the fit. It is not under the law. These sanctions are not to provide some windfall. And we briefed in our brief at pages 41, 42 through 44. These sanctions found specifically that they didn't meet the 3.2 hours of nursing that were required per patient, when the facts show from the discovery that on every day that of the 11 days that this patient was there, they did meet the 3.2. The issue sanctions say there's no fall prevention policy in place. The production shows, and we cite it there at those pages, there is a fall prevention policy in place. They find these companies are all alter egos for one another. There's no finding that there's anything in the lateness or the documents that were produced that showed that they were alter egos, that they even went to that issue. The fit that the discovery referee made here was not to any violation, but it was to the jury instructions. It fit the wish list that the plaintiff's counsel submitted to him of, these are what we'd like to have because of this late production. That isn't the law. So we went badly awry, both on there not being a violation of a court order, on a sanction for purposes of punishment, and with absolutely no fit or matching up with any violation, but rather matching up with what the ultimate jury instructions are. So this is not a case where the court should come in and rewrite the order below in order to then rule on the order that the counsel for the respondents would like to have. This is a case where you have to look at what the order is, and this order in no way can support the sanctions, either the issue sanctions or the monetary sanctions. Why not the monetary sanctions either? Because, as we know, monetary sanctions are only available where there's a finding there was no substantial justification for the position that the defendants took below. There is no such finding here, and none would have been warranted. The defendants put in ample evidence that this was 4.5 years when these nursing homes were rampaged by COVID, when they were short-staffed, when they couldn't run their facilities, and yet they complied with all of the rules here the best they could. They put in 50 pages, a chart of 50 pages of everything they had done in order to comply, being short-handed and short-staffed. This was a situation where there were 11 days spent at the facility, 44 depositions taken, 25,000 pages of documents produced, 82 motions. The referee made a specific finding that there was no stone unturned in discovery. That's in Exhibit 27 at page 3014. No stone unturned in discovery is the opposite of proportionate discovery. So the notion that there were, the defendant was not justified in resisting this motion and resisting these sanctions is not only not supported by the record, but there is no such finding in the record that that's the basis for the monetary sanctions. It's to deter future violations.
You have 3 minutes of your initial 20 left.
3 minutes. Well, let me then just complete this portion and save the last 10 with this comment. What should have happened? It wasn't impossible to get to these results if they were in fact merited. What should have happened? Well, what the referee should have been doing is first finding whether anything was not responded to or not produced. Was there something that was not complied with? Was there an answer that was not responded to or a document that was not produced?
Let me interrupt you, Mr. Howarth. When was that supposed to happen? Because as I understand from the record, there was all compliance with all of these orders by the referee were violated repeatedly. And so when was that supposed to happen, that he should have done that, or that the referee should have done that?
No, the basis for today's is not some repeated violation of orders. The basis for today's hearing is recommendation and ruling number 11. Right. And there is no finding that there's been repeated violations with respect to number 11. With respect to number 11, what he should have been doing is saying, here we have a motion to compel further responses to production of documents. Is there something that hasn't been produced? Is there something that hasn't been answered? And then second, if so, was that a violation of a prior order? And then was that willful? And there was none of that inquiry. The defendant has a right to come in, a due process right to come in and say, I want to address that question. They're all here, and that's what they did.
Then, in response to, what motion was it, 82?
82,
okay,
the
so
82nd motion.
At the time of the motion number 82, he should have made those findings and done what you're saying.
Exactly right, and then he should have said, if I'm going to give issue sanctions, then I need to connect it up with exactly what it was that wasn't answered or what it was that wasn't responded to so that it fits the crime, so that we don't have something which is to punish. And he should not be saying, I want to take this opportunity because we're at number 82 now, and I've been here all this time. I don't want any more, and so I want to deter the future. That isn't the role of these sanctions. I'll save them the 10 minutes for rebuttal if I can. Thank you.
Thank you, counsel.
Good morning. May it please the court, Victoria Fuller for the plaintiffs and the respondents. Your Honor, since you asked the jurisdictional question, I'll start with that. And I think before we even start talking about whether these issues are inextricably intertwined, I think we need to understand what Milikowski really says. Does Milikowski really say that appellate courts can create an exception or can create appellate jurisdiction? Because the legislature is the branch that has the power to do that, not the appellate courts. The legislature has never amended 904.1 or any statute to say, you know, in addition to judgments and post-judgment orders and what have you, courts may entertain a direct appeal of an otherwise non-appealable order if it's inextricably intertwined with, you know, an order that's directly appealable. So the legislature's never done that. And I don't think that Milikowski actually says that. I think what Milikowski did was basically save a premature appeal on those circumstances. So there, it was very different. There was a plan, well, the trial court awarded, it was terminating sanctions and monetary sanctions against a plaintiff. When the order came down, the plaintiff properly appealed from the order because the monetary sanctions were appealable. The trial court should have entered a judgment, but it didn't, thinking that there wasn't jurisdiction because there was a pending appeal. So in that case, the plaintiff couldn't file a notice of appeal from a judgment and join the issue of the terminating sanctions and that appeal. So the appellate court basically saved a premature appeal. But here, we don't have a situation like that at all. All we have are two aspects of an order, one of which is appealable and the other isn't. So I don't think Milikowski actually says that courts can do this, even if it's convenient for everybody. And I'll readily say at this point, the issue's been fully briefed at this point. It would be a lot more convenient for all of us just to get a decision on this now. But this is a question of jurisdiction. And the court either has it or it doesn't.
But that court said if it's intertwined, inextricably intertwined, then you can do it. And counsel is telling us, Mr. Howarth is telling us that if it's based on the same conduct, we can do that.
I don't think that Milikowski actually says that because the procedure was so different. Because they're looking at a plaintiff who's going to have a judgment, an appealable judgment, or should have had an appealable judgment and sued, and didn't. I don't think Milikowski said that in any other context, when you've got a defendant who's heading into trial, and there is an order, part of which is appealable and part of which isn't, that courts can now say there's appellate jurisdiction because it's a lot more convenient for everybody. I don't think that courts can do that. I think only the legislature can do that. And in mulling this over today, for the argument today, I thought of a couple of problems that could come about if an exception like this is carved out. And one is, could there be a waiver trap? So parties who are looking at an order like this, and they're looking at, are we going to appeal the monetary sanctions? Are we going to appeal some non-monetary sanctions? If they don't appeal both, if they wait for to appeal the non-monetary sanctions after a judgment, have they waived it? You know, that could be litigation that could come down, or answers that need to be, or questions that need to be answered. And on top of that, what about a stay? You know, here, the appeal should have been from the award of monetary sanctions, but the appeal of the issue sanctions stayed the entire case that was headed into trial after 5 years of litigation. And what about, does this come up in other consequences? You know, one thought I had for today was, what about an order, say, in a dissolution, where you have an appealable spousal support order, you have a non-appealable interim property division order? If they're related, do you have to appeal both? And if so, is there a stay of the non-appealable order? And the problem with that is if you research that, you're not going to find a question, because you're not going to find a case that says a notice of appeal from a non-appealable order stays the order because it's not appealable. So those cases don't exist. So I think carving out a judicial exception like this is really problematic, and I really don't think that Milikowski says that. So, and just to answer the question, are these issues really the same? I don't think that you have to go into this full record just to decide the monetary issues. I think the question of whether monetary sanctions were proper to compensate the plaintiffs for bringing another motion is different from the question of whether issue sanctions were required given the defendant's misuse of the discovery process in providing information so late that it was of no use. I don't think the reversal of one requires the reversal of the other or vice versa. So I don't think that they're inextricably intertwined. Moving on to the question of the court's findings. So the defendants argue, one of their principal arguments relates to findings that the trial court didn't make, express findings that the trial court didn't make. But that runs afoul of the rules governing appellate review and how they review trial court orders. Rather than allowing parties to just pick apart trial court orders and seek a reversal because the trial court didn't make express findings on certain details, appellate courts can infer findings that are necessary to support the order as long as they're supported by substantial evidence. And the substantial evidence doesn't mean, in this case, the defendant's evidence. That means disregarding all of the defendant's evidence. Was the plaintiff's evidence substantial? And the key criticism here seems to be, was there a finding that the defendants intentionally violated court orders? The trial court certainly found in this order that the defendants had repeatedly disregarded their discovery obligations. Their 11th hour production was not a good faith effort to comply. Instead, it was part of an effort to withhold information from the plaintiffs until it was so late that it wasn't useful. That, I think, is sufficient. And to the extent there are any certain details that are missing there, then this court can infer any other findings that are necessary. The reasons underlying the order, the defendants contend that it was an abuse of discretion to issue or award these sanctions on the basis that these responses were late. That's not the problem with these responses. The problem was that to the extent that the defendants did provide information, it was so late that it wasn't useful. And there are some examples in the respondent's brief, but I'd like to highlight a handful of others here. One is that the plaintiffs had to take the depositions of key, or I think all defense witnesses, without the benefit of basic discovery, including emails among the defendants, emails pertaining to the plaintiff, Ms. Matsumoto, and the operative fall management policy that governed the nursing staff's duties, which wasn't provided until those depositions had already taken place. The second example I'd like to highlight is that for years, the plaintiffs sought daily reports of nursing hours per patient day. They sought that information in an effort to disprove the defendant's claim that they adequately staffed the facility. Back in 2018, a defense administrator testified that those daily reports existed. Plaintiffs formally requested them. Defendants did not provide them. Defendants were ordered to provide the documents, and they didn't. In the 11th hour discovery responses, the defendants took the position that those daily reports had been lost. So at that time, not only did the plaintiffs not have the information, they couldn't take any depositions at that point to figure out, were they really lost? If so, how and when? And the last example that I'll highlight today is that those 11th hour responses finally produced CNA schedules, certain nursing staff schedules. But because the discovery cutoff was so close, there was no time to serve special interrogatories to get their contact information, and there was no time to notice depositions. So the problem was not that these were late. The problem was that the information, if provided, it was essential not just for trial preparation, but for use during discovery. And rather than forcing, extending discovery, forcing the plaintiffs to redo 5 years of discovery, the trial court awarded the issue sanctions to remedy the harm caused by the defendant's conduct. I just have 2 other points to address. One is, were these punitive? I think the Carol Richards case really talks about how do trial courts fashion issue sanctions. When a party propounds discovery, the opposing party, has the opportunity to participate and provide information. And when they don't, then they waive their ability to participate in a trial on that issue. And trial courts can deem established for the purposes of trial the facts or issues that the plaintiffs sought to prove, or that the propounding party sought to prove through the discovery requests. And that's exactly what happened here. It was a much bigger analysis and a much bigger undertaking here, but the plaintiffs submitted separate statements that were exhaustive. They spanned hundreds of pages, as I'm sure Your Honors saw in the record, and they identified every single discovery request, the information sought by the request, and how the information pertained to the issue sanctions awarded. So that's exactly what the trial court did here. I'd note that the defendants didn't even submit an opposition separate statement. They did not explain in their declarations, if it were true, that as to each discovery request, either the information was provided or these requests weren't germane to the issue sanctions. What they did do was say, well, gosh, we've provided a lot of documents. We've produced a lot of witnesses for deposition. That didn't answer the question. Finally, actually, I made my 2 points in one. Were these tailored to fit the crime? And I think my comments there just answered that question. I'd like to just finish my comments by saying, were the sanctions here or imposed here drastic? Yes, they were. But they were essential to remedy the harm caused by the defendant's extreme misuse of the discovery process here. The trial court's order was not arbitrary or capricious. It was more than rational. It was essential. And so unless the court has any further questions for me, I just ask that the court affirm the order in all respects to the extent that it reaches the merits. Thank you.
Thank you, counsel.
Counsel makes 4 essential points, and I think I can be fairly brief and direct in responding to them, Your Honors. First, with respect to Milikowski, Milikowski says exactly what we represented that it says, and I'm reading from it at page 276. Despite our attempts to limit the appeal, it appears from the parties' briefs that monetary sanctions were based on the same conduct that led to terminating sanctions. Thus, the two are inextricably intertwined. So it was exactly this situation, and the idea that this was to compensate, the monetary sanctions were to compensate them for the time in opposing the motion, is exactly the same as in Milikowski as well. And we cover that on page 21 of our brief, in the fact the monetary sanctions in Milikowski were based on the fees and costs incurred in prosecuting the motion for terminating sanctions. This is exactly parallel to Milikowski, and the urging this court not to follow Milikowski would be wrong and would be error. Now, counsel says that, well, there were all sorts of things that might happen in other cases. This is about discovery sanctions. This isn't about any other kind of cases. In discovery sanctions, the Milikowski rule says, where they come out of the same conduct, the appellate court reviews it only once, and it reviews it when the monetary sanctions are appealed. So it doesn't extend anything to some other case. with regard to the second point of you should infer some findings that weren't made, the law is very clear that you cannot attribute implied findings because there's nothing in the record here to suggest that the court ever considered these issues. And in fact, the court made, well, the referee, but the court adopted the express findings as the reason for the sanctions that I pointed out in my argument, timeliness and to deter future conduct. We cover this on page 20 of our brief, and there is the Reed versus Moskowitz case, where you have express statements by the trial court. The court will not presume some other findings. It would be a legal fiction that would deny due process. So you can't infer findings to get the order that the counsel wishes they had. Third, with respect to prejudice of the late production or late responses, they had, in fact, 6 months by the time this order was entered because the court had continued the trial. And the court had a number of vehicles available to it to find some lesser remedy if there were concerns about retaking depositions or retaking discovery. This was a wrongful death case. This wasn't someone waiting for their day in court. This was a relatives who were a nurse and a doctor who were bringing this lawsuit over an 11-day stay, and there was nothing that required an immediate, it's about money damages, as the court said below, and nothing else. So there is nothing here, no showing of prejudice that the court could not have cured, and no direction in the record, no discussion or direction of that issue to the court below or to the discovery referee.
Mr. Howarth, even reopening discovery at that point, with the 6 months, after the 6-month continuance, which I understand was beyond the 5-year statute, would have required probably more than 6 months, at least based on some of the information that we're hearing about the documents that were produced right before the original trial date, or one of the last trial date.
That was overstated and a disputed issue below. I'm giving credit to the argument that they say, oh, there are all sorts of things we needed to get. They had 44 depositions. They had all the information they needed to get about this 11-day stay. But the time to have argued that, if there really was going to be some prejudice they couldn't get done in the 6 months, would have been right then. And there was no finding on that. There was no finding that you can't get it done within the 6 months. That was the time to address those issues so that everyone had a chance to be heard on them, not at the appellate court level where they're saying, oh, we took this position, the defendants took the opposite position, we said everything had been produced, everything was timely there, and the referee made no finding either way. He asked that question, was the discovery complied with? And then he says, well, he did lots of things, but it was late. And that's the only basis for it. There's no basis that because it was for some other prejudice, and of course because they wanted to punish and deter future conduct. And that's the fourth point here. Was it punitive? She says, well, counsel says, well, plaintiff made these certain statements. They put in this evidence. They argued this below. The defendants did too. They each put in statements. As we pointed out in our brief, you can't litigate this based on the statements, the evidence they urged below when the referee didn't adopt that evidence. What he said is, for lateness and to deter future conduct, I'm going to give these dramatic sanctions. He doesn't match them up with anything in the record. He doesn't say, this was not produced and therefore we're going to take that little issue. He says, 3.2 nursing hours not complied with. He says, your alter egos. He says you didn't have a fall prevention policy. We know those are all false. The record is to the contrary. The referee below, which the court then just adopted, did not do what was required to be done to make these match. They don't match, and this court should reverse. Thank you very much.
Thank you, counsel. Well done. Matter submitted.
Thank you.
Nice job.
Oh, you too. Thank you
Good
very
luck.
much. Good luck. You too.
Nice to meet you.
Thank you.
nice to see you. Good night. Good afternoon. Getting ahead of myself.
Which I did pay attention, but I just wanted to make sure I'm broadcast. You know, could I just pause? Okay, that's good. I got out right away and I'm like, oh shoot, we're not doing that one, we're doing that. That was my, okay, so now I can get out of it now. Okay. Sorry, I just freaked out like, I was able to get out of it right away, so that was my question. Okay. Yeah, I'm turning the, thanks, I'm turning the log, you know, I can turn it here in the township, and I'm gonna turn it after. Is it at the Hewlett Packard one too? Yeah. Cause I did it last time, and I
know that it says PDF. I didn't know what it said before that.
Do I?
Yeah, so click on that. And then it's gonna bring up,
Oh, there it is.
okay.
Sorry.
Oh, you're good.
I'm like, I'm trying to do it that way. I've done it before. I forgot that that's mine.
Okay. So when you're all done, just leave, you can turn Granicus off, but just leave the computer on
Oh, okay.
so that I